All right. Can anybody hear me? Want to make sure you can hear me. Let me turn this volume up just to see. All right. Can anybody hear me? Okay. Anybody? Can you hear me? Before I begin, I got to make sure y'all can hear me because I can. I mean, I just checked it and I was able to hear me, but I want to make sure that y'all can hear me before I start the show. I'll be right back. Go back and check the chat. All right. Can anybody hear me? Anybody hear me? On a scale of 1 to 10, how good can you hear me? I need to make sure that y'all can hear me before I start the show. Anybody hear me? Anybody hear me? Anybody hear me? I don't see anything in the chat right now. I'm gonna try it from somewhere else. I'm not sure what the delay is or if I don't know what's going on. Um, your activity stream health. Okay, all right. I got two people saying they can hear me good. All right, cool, cool. All right, so I'm gonna go ahead and I'll go ahead and start the show. Um, but before I do that, if y'all don't mind, I would like, if y'all haven't already, to go ahead. Let me go here and I'm gonna show you what I'm talking about. If you haven't already and you want to support my channel, I would really appreciate it if you did. Go ahead and join one of my memberships. I don't care which one it is, this is whatever. Jury members is 99 cents. I strictly and intentionally made that 99 cents for a reason because I know, it's hard times out here, y'all. So if y'all don't mind, I would really appreciate it if you did. And thank you to everybody who has already done that. All right. I'll come back from time to time and check and monitor the chat. But let me go ahead and get right into this. All right. So the first thing that I want to talk about in regards is this, to this right to travel thing. Y'all hit that like button for me too, if y'all don't mind. Please go ahead and hit that like button. Um, the first thing we're going to talk about is I'm going to explain, if you haven't already seen it, this definition of driver. Um, Let me get, where is it at? I just had it up here. So I think it's this one right here. All right, right here. Because I think this is important because this will, in my opinion, it tells you how they're essentially they have hidden this term or whatever. So if you don't know what a driver is, this is the definition for a driver. Now, when you read cases, the cases will say that these words have their common meaning and understanding to it. This is the common meaning of driver. This is the common law definition for driver. So what they've done is essentially what I always tell you they do from time to time is they codify common law definitions, common law principles, things like that. They will codify them, meaning they will bring them from the jurisdiction of common law over into their jurisdiction, and then they will modify it. All right, that's what they do. So the term for driver, one employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a steel railroad, blah, blah, blah. This case right here, it's an Alabama Supreme Court case, all right? Right here. I have this case on my computer. I've read this case, all right? This definition, okay, that I just read y'all is not expressly mentioned in this case. If it is, I didn't see it. All right. However, it is implicitly mentioned in the case. So I don't care if it's expressly mentioned in there or not in this particular case because it's implicitly mentioned in the case. And since it's implicitly mentioned in the case, it's just as if it was expressly mentioned in the case. All right. So the next thing that I want to talk about, I want to show y'all something. I'm gonna pull this case up right quick, just to show y'all. Where is it? Let's go to downloads. This Davis something, I think. Davis. Where is it at? Well, you know what? Let's go here. We'll go here because it's in here. Everything is in here. It's in alphabetical order right here. So here's the case right here. All right. This case right here, I have to do this because I need y'all to understand like how these people think. So the legislature in this particular case, they tried to label a bicycle. They tried to label it as a vehicle. I think it was either as a vehicle or a motor vehicle. I'm not really sure. But it's one of the two. But the Court of Chancery, this is an equity court, by the way, so-called equity. They said based on the facts of the case that the bicycle did not come within the meaning of the statute or the ordinance. I want y'all to pay attention to this too. The mayor and general counsel of the city of Mobile on March 16, 1896, adopted a general license ordinance, levying a license tax against against all trades and occupations carried on in said city, and included therein a license tax on bicycles. The complainant owned and used a bicycle solely and exclusively for his pleasure and conveyance, and his bicycle was not used in any way for the transportation of goods or merchandise, and was not kept for hire at any place in the city of Mobile. If that bicycle would have came within the meaning, what do I mean by that? Let me backtrack a little bit. If this bicycle was used for the transportation of goods or merchandise, all right, it would have been a vehicle, despite the fact that it is actually a bicycle. This is how these people think. This is why people call us crazy, but we're not crazy. We're not crazy. Tonight, I'm going to expose this. I'm gonna use case law, and then I'm gonna read y'all the case that actually expressly says you don't need a driver's license unless you're engaged in basically interstate commerce or intrastate commerce or whatever. It's interstate commerce or intrastate commerce. If you're not doing business, then you don't need a driver's license. So I'm not going to read this whole case. I skimmed through it because I want y'all to see it. So this is essentially what the appellant is arguing. The undisputed facts are that the bicycle owned by appellant was not used in the transportation of goods and merchandise or kept for hire. The ordinance levying a license tax, a license is a tax, y'all. I don't care if they don't call it a tax, it's a tax. Thereupon was unauthorized, null and void. Power to license, tax, and regulate horses, railroads, hackney carriages, etc. does not extend to the taxation of private vehicles used by a merchant or manufacturer. The bicycle owned by the appellant does not belong to the class of vehicles upon which the city of Mobile had authority to levy a tax. So essentially what they're saying is they're not saying that the passing of this ordinance was in a manner that is contrary to the Constitution or contrary to their charter. They're saying the way that this ordinance is applied, it's unlawful, meaning it doesn't lawfully apply to him. That's what they're saying. So let's go. What we got? There's some stuff in here that I just highlighted and I wanted y'all to see. And I think this is the argument for. I would say this is the argument for the government, which is the city of Mobile. Let's see. I'm trying to see where's the opinion of the court at. I don't see the definition. Let me see. It's not in here. Let me see. Where's the? I might have passed it, y'all. I probably passed it. I'm not gonna read this whole case. I want y'all to go and read this case. Let me give y'all the case citation again, so y'all can see this stuff. This is the case citation right here, 112 Alabama 654. It's from 1896. This is not the case that y'all came to watch the video for. I'm just showing y'all this little rabbit trail. All right. Now this case is from 1896. All right. So I'm gonna skip this. I want y'all to go and read this. Go and read this case when you get time. It's only 10 pages. Go and read this case. All right. Now I want to go to right here. Damn it. It's all right. I gotta pull it up again, y'all. I forgot I just restarted this damn computer. So I gotta redo it. I gotta put this damn thing in again. Let me close that. Alright. Where are we at? Alright, let me go back. Alright, so I'm trying to go to this law dictionary. Y'all just bear with me, alright? I'll get to the case in a little bit, but I gotta lay a foundation for my argument. Where is it's gonna be down here? Right here. We got this one. This is a Black's Law Dictionary from 1891. All right. I want y'all to see how old the dictionary is, though, and then I'm gonna give y'all the reason for it. Where's it at? Right here. A. All right. This is a Black's Law Dictionary. All right. Black's Law Dictionary, published in 1891. Now, this case that I just showed y'all is from 1896. So this law dictionary is older than this case. But I want y'all to pay attention to this definition for the word driver, because they're hiding this stuff. I don't care if they modify the statute or whatever. It still has the same meaning. I mean, not statute, the common law principle. I don't care if they did that because it still has the same meaning. So D. Now, if you look in this law dictionary, these are all the sections in the D's. Driver, one employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals. All right. So now we've got that established. We know what a driver is now. This is the common understanding and meaning of what a driver is. All right, but you got to understand that this definition it's going to be modified over time, but essentially this still is what it means. All right. So now the next thing I want y'all to see is, let's go to these cases. Where are we at? Right here. All right. Now let's go to this case. This is 2022. We all know this stuff, but I still got to show you. Okay. I got to go through this, and I got to show you. All right. So let's see. So on February 25th, 2022, plaintiff was traveling on Cape Coral Parkway in Cape Coral, Florida. The tags on his car clearly displayed that he was a traveler, not for hire private property. He has every right to do that on his car. It's private property. As a matter of fact, that the tag in itself is also private property. And if they take that tag off of your car and try to use it as evidence, I would sue these people because that is private property. I don't care if they take a shirt off of your back. That is private property, and you can sue them for it. Nevertheless, he was pulled over by a defendant police officer, Carol, I don't even know how to pronounce that. Anyway, who approached his window and requested plaintiff's driver license. Plaintiff informed defendant, whatever her name was, that he was a traveler. Defendant, whatever her name is, called for backup, and the police forced plaintiff out of his car. The police continued to demand a driver's license, and plaintiff continued to inform them that he was a traveler, and he stated that he was a citizen of the Republic of the United States of America. There's nothing wrong with that, because there is a Republic of the United States of America, because we don't have a democracy. The police then arrested plaintiff, hypothecating his name and making him a citizen of the U.S. corporation. So this is what he alleged in his complaint. We're going to go down. We're going to go down. When I read y'all, not this case, the case that actually holds it, you're going to understand why I say these people are committing treason, because that's exactly what they're doing. Let's see. This argument is similar to those exposed of self-proclaimed sovereign citizens, as explained in a 2019 Law Review article. The most common type of sovereign citizen claim encountered by local and police, as well as a federal border patrol agents, is the right to travel. Citing the Constitution, Supreme Court cases, and a plethora of other sources, sovereign citizens believe that they are not required to have a driver's license, license plates, vehicle registration, or to stop at border or sobriety checkpoints. Similar to other claims, sovereign citizens discussing the right to travel places special emphasis on the words being used. So they saying that so-called sovereign citizens are just making up words, making up their own words. This is why people, man, I don't even want to talk about it, because it's really starting to piss me off, to be honest with y'all. I don't even want to talk about it. They differentiate between a driver and a traveler, an automobile and a motor vehicle, commercial and non-commercial, and public versus private conveyance. I've read cases on all of this stuff. And they right. So-called sovereign citizens are right about all of this. Everything that this is saying. Once a sovereign citizen claims that he or she is merely a traveler or traveling, he or she then uses federal or state cases to support the right to travel. Sovereign citizens also believe the right to travel constitutes a complete bar on government interference with travel in the absence of probable cause or evidence that a victim has been harmed. To a certain extent, that's true. Now, here are all the cases of these so-called federal judges. They're not judges, they're executive administrators. But anyway, these types of claims that a plaintiff is entitled to a different treatment as a sovereign citizen are routinely rejected by federal courts as frivolous. They don't ever address the merits of it, and they're not going to address the merits of it. This is why I don't argue this in federal court. by the way. Not because you're wrong, because you are not wrong to argue that. But the reason why I don't do it is because these are not honorable men and women that you are dealing with. These people are knowingly committing treason. I'm gonna read a little bit more off this, and then I'm gonna go to the next one. All right. I'm laying a foundation. It's gonna slowly start to come together, y'all. Just bear with me. All right. Noting that so-called sovereign citizens are individuals who believe that they are not subject to court's jurisdiction and that courts have summarily rejected their legal theories as frivolous. Describing the conduct of a sovereign citizen and collecting cases rejecting the group's claims as frivolous and recommending that sovereign citizen arguments be rejected summarily, however they are presented. Blah, blah, blah. Sovereign citizen argument that motor vehicle registration and licensing laws do not apply to plaintiff rejected as frivolous. All right, I'm going to stop right there. All right. So now the next thing I want to point out is this case. This case right here. All right. So we'll close this one. We'll go here. All right. This is a West Virginia Supreme Court of Appeals case. All right. Pro se plaintiff Joshua Black appeals the Circuit Court of Randolph County's October 30th, 2014 order finding petitioner guilty of one count of driving on a revoked license, second offense in violation, blah, 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 and imposing a fine in the amount of $100 plus costs. Let me see. We're going to see what his argument is. On appeal, petitioner argues that one, West Virginia Code, blah, 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 is unconstitutional because it violates his constitutional right to travel and to pursue life, liberty, and happiness, and he is only required to obtain a license to drive a vehicle on public highways as roads if he drives a vehicle on public highways for commercial gain. That is he's right. He is absolutely right. He is 100. I'm not 99. No, he is 100% right. Give me a second. I'm gonna show you. Now I'm gonna show y'all the treason that these people do in this case. The treason they are intentionally doing this, y'all. So right here, it's petitioner. When they talking about petitioner, they're talking about the guy who got the traffic ticket. All right. Petitioner relies upon this court opinion in Ex parte Dickey, West Virginia, 76, West Virginia 576, in support of his claim. But Dickey does not stand for the proposition that the West Virginia legislature lacks the authority to impose licensing requirements on citizens. No, it doesn't. Unless it's for traveling and not for private gain, not for hire. Dickey is also clearly distinguishable from the case at bar. In Dickey, this court was confronted with a challenge to a municipal ordinance regulating common carriers operating on public highways. Importantly, in that decision, this court noted that as to the right of the citizen to travel upon the public highway and transportate his property thereon, the extent of the legislative power, the extent of legislative power is that of regulation. I want y'all to see how misleading that is. She did that on purpose. A woman did this, by the way. She did that on purpose. When I read that, I knew for a fact that she left out a whole lot in that case citation. All right, I'm going to stop right there because I'm going to take y'all to the case citation and tell you exactly what it says. And this is a principle, by the way, because there are a plethora of other courts that hold this same exact thing as in Ex parte Dickey. All right. So let's go to Ex parte Dickey. Ex parte Dickey, where we at? Right here. All right, let's get to it. Let's get to it. What page is on? Now, this is 12 pages. I kind of don't want to read all of it, but I do want to show y'all the case citation. All right. Let me give y'all the court. Well, I already gave y'all the case citation, but let me read this to y'all. And I'm gonna go back to that case and show y'all everything she left out. All right. The right of the citizen to travel upon the highway and transport his property thereon. This is what she left out right here. In the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus. The former is the usual, meaning the right to travel, and ordinary right of a citizen, a common right, a right common to all, while the latter is a special, unusual, and extraordinary. As to the former, and this is how she put it, the extent of legislative power is that of regulation. See how she tried to hide that, y'all? Do y'all see? This is what they do, y'all. This is what they do. This is why you do not believe everything these people tell you, because they are knowingly committing treason. Do not believe what these people tell you. Do not believe what these people tell you. She left out right here. She left out this right here. She left out all that. She left out all this. This is what she left out. Everything I'm highlighting right now, she left all that out of the case citation. All of it is out of the case citation. Go read the case for yourself. If you think I'm lying, go read this case for yourself. Now, what I'm going to do is I'm going to go to other cases from other so-called states that hold this same thing, showing you that this is a principle and that this applies everywhere. That's what I'm going to do next. Look at this. Man, these folks get on my nerves, man. They get on my nerves. All right. What else we got? Dickey principle right here. This is a Kansas case. All right. Kansas Supreme Court. Out of Kansas. By the way, all the people in these cases, if I'm not mistaken, they lost these cases except one because they were using the roads as a place of business. Of course, you're gonna lose the case. So let me see. Let me see. If continuous and I might need to go up and read a little bit more. I'll do it right here. And then I'm going to give y'all that case citation too so y'all can go and read it for yourself. But here it is again. In Kansas, they're citing Ex parte Dickey as a principle. This is a principle. The right of the citizen, let me make it bigger. The right of the citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain. In the running of a stagecoach or omnibus, the former is the usual and ordinary right of a citizen, a common right, a right common to all, while the latter is special, unusual, and extraordinary. As to the former, the extent of the legislative power is that of regulation. But as to the latter, its powers is broader. So what do they mean by as to the latter? They meaning if you're using the roads as a place of business, then they have more authority to restrict that occupation, because essentially it's an occupation. They can't require you to have a license to use the public highways. Why can't they do that, y'all? I'm gonna read it to you right here again. Where is it at? The reason why is because the former, which is the right to travel, is the unusual and ordinary right of a citizen, a common right, a right common to all, to everybody. That's what they mean. While the latter is special, unusual, and extraordinary. As to the former, the extent of legislative power is that of regulation, but as to the latter, its power is broader. All right. The right may be wholly denied if you're using it as a place of business. They can just outright deny it. or it may be permitted to some and denied to others because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all authorities. They mean it is recognized all over the country. That's what they mean when they say that. That's exactly what they mean when they say that. In Green versus City of San Antonio, I'm going to go and read that case because they also, if I'm not mistaken, they cite ex parte dickie in that case. No man has the right to use a street for the prosecution of his private business, and his use for that purpose may be prohibited or regulated as the state or municipality may deem best for the public good. All right. Let me give y'all this case citation. I'm going to close it. I'm going to give y'all this case citation so y'all can go and read it for yourself. It's right here. This is a Kansas case, all right? It's volume 109, Kansas Supreme Court. You can find it on page 796. This case was decided in 1921. All right, let's go. Let's go up a little bit more. Where we got... I think I got to go down some. Give me a second, y'all. I'm trying to find more of them with the ex parte dickie in it. I'm going to try to do 3 of them, and then that'll be it right here. All right. Gill versus City of Dallas. All right. 5 pages. It's a little small. Just to let y'all know, it took me a while to find this case, y'all. It took me, well, I ain't going to say a while, but I was searching for it for a long time throughout the day. So I think it took me about 4 or 5 days to find the case that I'm going to read to y'all later tonight. It took me about 4 or 5 days. But I'm trying to point this out to you. I have to do this because I want y'all to see this stuff, all right? So what we got? It's right here. It starts right here. While the, and then it goes back up. Hold on. Is that it? Is that, I'm trying to, I think that's it. Let me go back up, y'all. These words are so damn small, I can't even see it. I think that was it. Yeah, that was it. All right, that was it. All right. Let me see, y'all. Action regulated provisions. Right here. Okay. While the right to use the public highways for ordinary travel or use, and incidentally, the transportation of one's business is a common privilege of the public. The right to use such highways upon which to conduct business or to put such highway to some peculiar, special, or exceptional use in order to conduct or maintain business thereon is always subject to the will of the state or the political subdivisions thereof, to which such power has been delegated. It is, of course, a well settled and general accepted rule that municipalities may not prohibit occupations or businesses lawful under general laws, though generally speaking, they may license and regulate under authority of legislative grant. Whether one in pursuit of a lawful business or occupation may put the public highways to a peculiar or exceptional use, that is to say, conduct his business exclusively thereon, is widely different. So it's a widely different matter. Certainly, the citizen has no common or inherent right in that respect. They're saying you can't use it for business purposes. That's what they're saying. I'm gonna go and do one more case, and then I'm gonna go to something else. And I want y'all to see this stuff. I'm gonna go and do one more. Let's see. That's not it. What we got? Trying to find it, y'all. Right to travel. Right here. All right. Here's another one. This will be the last one. This is a if I'm not mistaken, I think this is a Kentucky Supreme Court case. Let me go and check. Yeah, this is a Kentucky Supreme Court case. It is on volume 209, and it's on page 40. So that's where you can go to find that case and read it at. All right. I'm not going to, excuse me, I'm not going to read this whole case. I'm going to get to the point. I know I highlighted it. Right here. I highlighted a lot of, I did a lot of reading, y'all. I did a lot of reading. All right. So here it is right here. The right of the citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus. The former is the usual and ordinary right of a citizen, a right, let me see, of a citizen, a common right, a right common to all, while the latter is special, unusual, and extraordinary. And as the case, ex parte Dickey. Let's go down. Just read a little bit more. So, in this case, appellate has never had any vested right to use the streets of San Antonio to engage in the business of a common carrier of passengers for hire, and no right of his is infringed or invaded by the ordinance requiring certain things to be done in order to enter into business. Notice they saying business. This is all business, y'all. On the streets, which have at the expenditure of large sums been placed by the city in prime condition for automobile travel. The streets belong to the public. The city being its trustee, and no private individual or corporation has a right to use such streets for the purpose for the prosecution of a business without the consent of the trustee and compliance with the conditions upon which the permission to so use them is given. The streets and highways belong to the public. They are built and maintained at the public expense for the use of the general public in the ordinary and customary manner. The state and city, as an arm of the state, has absolute control over the streets in the interest of the public. No private individual or corporation has a right to use the streets to I can't even get the words out of my mouth, y'all. Corporation has a right to the use of the streets in the prosecution of the business of a common carrier for private gain without the consent of the state, nor except upon the terms and conditions prescribed by the state or municipality, as the case may be. Thus, the use of the streets as a place of business or as a main instrumentality of business is accorded as a mere privilege and not as a matter of natural right. All right. So what else we want to go to? All right. So now that we got that established, let me check the chat right quick. Now that we've established that, let me check this chat. See if I got any questions, whatever. Thank you for your guide. You're welcome, man. No problem. No problem. Y'all hit that like button for me. Y'all don't mind? Hit that like button. Hit that like button for me. All right. So let me explain something to y'all what they mean by travel. Let me give y'all some examples of what traveling is. So let's go back up. The right of the citizen to travel upon the highways. So we're going to start right there. What do they mean by travel? There are different modes that can be used for you to travel. For example, you can get up, say you're sitting down at a park or whatever, you're sitting on a bench and you want to go throw some of your trash in the trash can. You get up and you walk over there and throw it away in the trash. That is traveling, ladies and gentlemen, using your feet to move from one place to another, because that's all traveling is, moving from one place to another. I don't care how far it is or how short it is, it's traveling. That's what traveling is. All right. So skating is a mode of traveling. Bike riding is a mode of traveling. Using a motorcycle is a mode of traveling. Using a scooter is a mode of traveling. Using a skateboard is a mode of traveling. Using an automobile is a mode of traveling. Using horses is a mode of traveling. Is this making sense for y'all? Is that making sense for y'all? Because it makes perfect sense to me. That's traveling. All right. Now we're gonna get to this case. Let me make sure I didn't miss anything. I gotta make sure I covered everything that I wanted to. I think I did. I don't want to make this too long. So let me get to the case. Let me give y'all this case citation. Now I found this case, the case that actually holds it. This is gonna blow y'all mind. It's gonna blow y'all minds, fam. Um, Let me delete all that. I don't need that no more. Let me give y'all the case citation. I have the case citation in my head. I made sure I remember that. So let me give y'all the case citation because I want y'all to see it for yourself. This is the case citation. Cannot believe this case was on case text. I can't believe that. This is the case right here. I'm gonna copy and paste this case and give it to y'all. Hopefully it'll be able to be put in the group. Yeah, right here. Right here. All right, this is the case right here. All right, I just posted the link to the case in the chat. All right, now I'm about to read y'all this case. All of this stuff is commercial. It's all commercial. Now I'm about to read y'all the case. Y'all, this is the case citation right here. 175 Illinois 445. It was decided in 1898. This is the Supreme Court of Illinois. They are sitting in equity. Somebody filed a bill to enjoin them from enforcing an ordinance requiring them to get a license on their private cars that they using. Right here. Let me pull it up. City of. Is this it? Right here. All right. I went and downloaded this case. I'm gonna start from finish. Start to finish. All right. So this is the judge name, Honorable Murray T. What is it? Tolley. This is him right here. I had to go and look him up. This is the judge, so-called judge anyway. He wrote this opinion. He did a really good job with this opinion. All right, I'm gonna make this bigger so everybody can see it. I don't want to read everything, but I feel like I have to. So this will be the only case that I'm going to read this entire case. All right, give me a second, y'all. Let me get me a drink of water, and something to snack on because I'm hungry. Give me a second, y'all. I'll be right back. Sorry, I had to get me a little something to snack on. Still home. All right, y'all. I'm sorry. I'm back. I'm back. All right. Hopefully, I didn't forget anything. I probably forgot something. But all right, let's get into it. The appellees, 373 in number, residents and taxpayers of the city of Chicago, suing in behalf of themselves and all others similarly situated, filed a bill to enjoin the city from enforcing an ordinance providing that all vehicles used upon the streets of the city, sorry about that, used upon the streets of the city, including those for private use, for pleasure, etc., should pay an annual license fee, and that any person using any vehicle without first having obtained a license, therefore, or failing to have said vehicle properly tagged so that it would appear the license had been paid, should, on conviction, be fined a sum of not less than $10 nor more than $50 for each offense. The ordinance requires wagons, carriages, coaches, buggies, bicycles, and all other wheeled vehicles propelled by horsepower or by the rider shall be so licensed. The ordinance also provides that all money received under or collected from the operation and enforcement of the ordinance should constitute a separate and distinct fund to be known as the wheel tax fund. The sole object and purpose for which said wheel tax fund might be dispersed should be for repairing and keeping in good condition the streets of the city, and should, upon the recommendation of the council, be distributed in the 34 wards of the city of Chicago. At the time of filing the bill, we in equity, y'all. So that's why they're gonna always say a bill. This is the Supreme Court of Illinois. They are sitting in equity. They are exercising equity jurisdiction. At the time of the filing of the bill, this ordinance was in full force and effect. It will be seen from an examination of such ordinance that it imposes a license fee or tax on all vehicles used on the streets of Chicago, even those in private use and not for hire. I'm sorry, and not for let or hire. All of the appellees are owners of bicycles and many of them other wheeled vehicles propelled by horses. 300,000 bicycles and carriages in private use only are affected by the ordinance. The appellees use their bicycles not for the purpose of traffic, or for carrying merchandise or passengers for hire upon the streets of Chicago, but solely for their private use and as a means of locomotion from place to place, which means traveling. Not letting or hiring either said bicycles or wheeled vehicles to any person or persons whomsoever, and 300,000 other vehicles in the city of Chicago, all of which are subject, all of which are subjected to the tax license imposed by the ordinance are similarly used. All personal property of the appellees owned by them on May 1st, 1897, subject to taxation, has been listed and assessed for taxation. And inasmuch as the law is uniform, it is reasonable to conclude that all other personal property, including the 300,000 other vehicles affected by the ordinance, has been similarly listed and assessed. The fiscal year of the City of Chicago commenced on January 1989, and long prior to the enactment of the ordinance in question, the City of Chicago had passed the annual appropriation bill provided by Section 2 of Article 7 of the General Act relative to cities and villages, providing that within the first quarter of the fiscal year, such appropriation bill shall be passed, by which the corporate authorities may appropriate such sums or sums of money as may be deemed necessary to defray all necessary expenses and liabilities of such corporation. And in such ordinance shall specify the objects and purposes for which such appropriations are made, and the amount appropriated for each object, and no further appropriation shall be made at any time within the fiscal year without the sanction of the majority of the legal voters of the municipality. The bicycles owned by the appellees range in value from $5 to $1,500. Who's paying $1,500 for a bicycle in 1859? That's crazy. Anyway, and the value of the other wheeled vehicles from $25 to $5,000. And it is not denied by the answer that every day the appellees use one or more of their vehicles, and that inasmuch as they are confined during the working hours of the day very closely to their places of business, it is needful for their health and mental and bodily vigor that they take exercise in the streets, boulevards, and parks of the city. That many thousands of people in the city of Chicago are similarly situated, and that unless they submit to the exaction of the illegal ordinance, they will be debarred of the privilege of so using the streets, and will be greatly injured in their physical health and enjoyment. It is contended that the ordinance is void because the city has no power to require a license for private vehicles used on the streets of the city, nor to impose a tax by way of license. That a tax so imposed on vehicles on account of their different values would not be uniform, that great injury would result because of the injury to health, and because of the interference with the right of complainants to use the streets. They're saying you have a right to use the streets, and consequent injury to business by the prevention of free locomotion from place to place, and by the citizens being harassed by red. Look at this, y'all. They tried to do this over 100 years ago. This is the same thing that happened to us today. Fear of being arrested because we're not complying with an ordinance that is not lawfully applicable to us. The bill prayed for an injunction perpetually enjoining the enforcement of the ordinance. The answer averred the right to enact and enforce the ordinance, and asserted complainants had a remedy at law. When they say at law, they mean common law, if any existed. The cause was heard on a stipulation as to the facts, which embraced the facts as averred in the complainant's bill. The stipulation showed the streets at night are full of passing vehicles, that the bicycles is almost noiseless, and chances of accident to persons using the streets have greatly increased because of its use. That the city has been obliged to enact rules regulating the use of the streets because of the changed conditions. That prior to the passage of this ordinance, the city was obliged to impose rules requiring bicycles to carry lights after dark, limiting their speed, regulating the meeting and passing of other vehicles and persons, and otherwise regulating the use of the streets. That many vehicles, especially those used for pleasure, are now fitted with rubber tires and move with but slight noise, so that persons using the streets have little warning of their approach. Let's see. What is this for? Appellant. A court of equity has no jurisdiction over the subject matter of the bill of complaint. So they're arguing that they didn't have jurisdiction. Yada yada yada. Blah blah blah. Let's get down to the actual opinion. This is a very good case. I strongly advise y'all to go and read this case. This is a very good case. Okay, I gave y'all the wrong judge name. That was from a previous case. I'm sorry. Mr. Justice Phillips delivered the opinion of the court. I got to go and check and see who that is. All right. Two questions are presented by this record. Has a court of equity jurisdiction to enjoin the enforcement of an ordinance of a city, and has the city, under the expressed or implied powers conferred on it by the legislature, authority to adopt this ordinance? The enforcement of a void city ordinance may be enjoined in order to prevent a multiplicity of suits at the instance of any person whose interests are impaired by it. A court of equity, however, cannot determine whether the ordinance has been violated, but merely whether it is void. Where such court is resorted to on the ground of prevention of multiplicity of suits, there must be a right affecting many persons. And this is Palmery. Palmery is the equity jurisprudence. Palmery, in his work on equity jurisprudence, in treating of the jurisdiction of courts of equity on the ground that divides them into four classes, and in the third and fourth classes states the principle. Third, where a number of persons have separate. Let me stop right here, y'all. They're giving you the game right now in this case, how to potentially get a permanent injunction from the corporation of the so-called city of whatever from unlawfully enforcing this motor vehicle ordinance on you. They're giving you the game right here in this case. Third, where a number of persons have separate and individual claims and rights of action against the same party, but all arise from some common cause, are governed by the same legal rule, and involve similar facts, and the whole matter might be settled in a single suit brought by all these persons uniting as co-plaintiffs, or one of the persons suing on behalf of the others, or even by one person suing for himself alone. See this, y'all? They're giving y'all the game, man. The case of several owners of distinct parcels of land upon which the same illegal assessment or tax has been laid is an example of this case. Fourth, where the same party A has or claims to have some common right against a number of persons, the establishment of which would regularly require a separate action brought by him against each of these persons, or brought by each of them against him. Instead thereof, he might procure the whole to be determined in one suit brought by himself against all the adverse claimants as co-defendants. So essentially, what the chancellor in this case is doing is he's establishing that he has jurisdiction to decide this case. That's essentially what he's doing. It is familiar that on this ground, taxpayers of a town, city, or county, or other taxing district may file a bill to restrain or set aside any legal general tax, whether personal or made a lien upon their respective property. And these are all the cases right here to support his contention. These are principles, by the way, y'all, just to let y'all know. There are a lot of principles in this case. The claim that the failure of complainants to pay this tax and resort to legal actions to recover the amount precludes equitable interference cannot be sustained. So they're overruling that contention. They're saying that contention is without merit. Many cases undoubtedly exist where equity will interfere to protect an invasion of property rights, where the remedy at law is not entirely adequate, and where peculiar difficulties intervene, the jurisdiction will be upheld. In the present case, 373 complainants have filed their bill for relief. Their grievance is precisely the same as arises from the same cause. The various parties aggrieved although not jointly interested, are allowed to sue together for the express purpose of avoiding a multiplicity of suits and to have the controversy settled in one. This is case law. Y'all can use this case law in Illinois right now in regards to traffic tickets and saying you need a driver's license and all that stuff. The case ain't even got good yet. Y'all just wait. The municipality is charged with a public trust, and where it is about to commit an act clearly illegal, the necessary effect of which will be to impose heavy burdens upon the property of citizens and taxpayers, it becomes amenable to the jurisdiction of equity for a breach of trust. You breach that trust. You taxing private property. You are unlawfully taxing private property. And such court may interfere by injunction for the prevention of such act. Where the controversy is between two parties only, or where but few persons are involved, then, unless complainant's rights have been established at law, a court of equity would not intervene. No flexible rule can be laid down for determination of the question as to whether jurisdiction exists in a court of equity. In general, an adequate legal remedy will suffice to make such courts hesitant in acting. But inadequacy in granting relief for the determination of a right may arise from causes other than mere forms of remedy. And it will not do to sacrifice justice on the mere ground of the form of the remedy, where convincing facts show that adequate relief can best be had in the form of a court of equity. In this case, 373 complaints present facts showing that between 200,000 and 300,000 citizens and taxpayers are affected by the provisions of ordinance, and if compelled to pay the illegal tax, hardship and injustice will result to an enormous number of persons. Let me stop right here, y'all. Let's go to, I want to say something. Let me go back to the chat right quick. I want to say something. They are never going to tell y'all this. The judiciary in the past, they did their job, y'all. Based off the cases that I read, they did their job. They did their job. The judiciary of today, they are not honorable men and women. You can forget about that. The reason that they are not going to tell you this is because this is about money. That is the whole purpose behind all of this. This is all about so-called money. That's it. Y'all hit that like button. Hit that like button if y'all don't mind. Hit that like button. This is about money. That is it. That's it. It's about money. That's it. So let me show you what I mean. What do I mean by that? So let's do I'm gonna get back to the case in a minute, y'all, but give me a second. We're gonna do Texas for an example. So we're gonna do the Texas population. All right. Let's see. That's 2020. Let's see what it did. Texas population. All right. So this is Texas population. All right. So I know this won't be true. All right. But let me give y'all an understanding of what I'm trying to do. So let's just assume that 30 million people, 503,000 people in Texas have a driver's license. All right. So we're going to say 30 million, 503, 301 people have driver's license in Texas. Now let's see what the Texas driver's license. Let's see how much a Texas driver's license costs. Just looking for the regular standard fee. Let's see, driver's license fee, Department of Public Safety. I'm not sure if this is accurate, but we just gotta do some. Under 18. Let's right here. So we're gonna say it. We're gonna go right here. So the average man or woman in Texas right now is probably paying about $33 for a license. All right. So we're gonna do that 30 million that I just said. We're gonna times that by 33. That is a billion. That is over. It's a slightly over $1 billion. That is why they are not going to tell you that. You can forget about it. They are not going to tell you this. That's why they're not going to tell you. Not only that, because once people wake up and they realize this stuff, they're going to start thinking, well, if they lied to us about that and we don't need a license for this, then maybe we don't need a license for this, or this, or whatever. It's going to make people lose trust in their government. It's going to make people question the integrity of their government. And then all hell gonna break loose once everybody start reading and finding stuff out on their own. It's just that's what's gonna happen. Let's get back to the case. They're not gonna tell y'all this stuff, but I promise this case right here is clearly telling you this. It's gonna get there in a minute, y'all. Give it about 10 minutes or less, and it's gonna get there. In this case, 373 complaints present facts showing that between 200,000 and 300,000 citizens and taxpayers are affected by the provisions of the ordinance, and if compelled to pay the illegal tax, hardship and injustice will result to an enormous number of persons. If they pay the tax and are compelled to resort to a court of law to recover back the amount so paid, the business of the courts will be so obstructed by the number of actions of the same character. A long delay will ensue, and the cost to the persons so paying such illegal tax or license fee will be greater than the amount to be recovered. That's inequitable. You can't do that. Under any circumstance, if the license exacted is illegal, it would amount to oppression and injustice to a large part of the population of the city of Chicago, and this bill presents a case for the jurisdiction of the Court of Equity. The contention of appellant is that the ordinance was lawfully passed under the powers delegated to the city by the General Incorporation Act, under which it was organized. All right, let me stop right there and say this. Just because an ordinance or a statute is lawfully passed does not mean that they can't enforce it in an unlawful manner, because that's exactly what they're doing in this case. They're enforcing it in an unlawful manner. The Act, by Section 1 of Article 5, provides the Common Council shall have the following among other powers. Clause 4, to fix the amount, terms, and manner of issuing and revoking license. Clause 2, to lay out, establish, open, alter, widen, extend, grade, pave, or otherwise improve streets, alleys, avenues, sidewalks, wharves, parks, public grounds, and vacate the same. Clause 8, to plant trees upon the same. Clause 9, to regulate the use of the same. Clause 10, to prevent and remove encroachments or obstructions upon the same. Clause 11, to provide for the lighting of same, to provide for the cleansing of same. Clause 92, to prevent and regulate the rolling of hoops, playing of ball, flying of kites, or any other amusement or practice having any tendency to annoy persons passing in the streets or on the sidewalks, or to frighten teams of persons. Clause 75, to declare what shall be a nuisance, and to abate the same, and to impose fines upon parties who may create, continue, or suffer nuisances to exist. Clause 78, to do all acts, make all regulations which may be necessary or expedient for the promotion of health or suppression of diseases. Clause 68, to regulate the police of the city and to pass and enforce all necessary police ordinance. Clause 96, to pass all ordinances, rules, and make all regulations proper or necessary to carry into effect the powers granted to the cities or villages. If I was y'all, and I was living in a so-called city, I would be trying to get a copy of that city's charter and read it. That's what I would be, because I have a copy of a city that I litigate in a lot. to pass all ordinances, rules, and make all regulations proper or necessary to carry into effect the powers granted to the cities or villages, with such fines or penalties as the city council or board of trustees shall deem proper, provided no fine or penalty shall exceed $200 and no imprisonment shall exceed 6 months for one offense. The principal contention of appellate is that under Clause 9 of Section 1 of the Act, which grants the power of the Common Council to regulate the use of the streets, the implied power is conferred to require a license to use the streets, as it has been frequently held by this court that the power to regulate, being expressly granted, the power to license as a means of regulation was clearly conferred. I agree. They do have the right to do that, but not on private property, not used for commercial purposes. They don't. All right, y'all, pay attention. This is where it's going to start getting good. Give me a second. I'll be right back. Give me a second. All right, sorry about that. The streets and alleys of a city are held in trust by the municipality for the use of the public, for purposes of travel thereon, and as a means of access to and egress from buildings abutting thereon or lots adjacent thereto. The right to travel on and along the streets of a city belongs to the general public and does not belong to its denizens alone. The right to travel being in the general public everywhere, all persons have a right to pass along and use the streets and alleys of a city in all their parts, the full width and length thereof. The municipality, which is a mere trustee of the public and holds the streets and alleys in a trust for the public, cannot deny the right of the public to use the streets and alleys. It cannot assume an exclusive ownership and deny the rights of the beneficiaries. What beneficiaries are we talking about? Who are the beneficiaries? You are the beneficiaries. They are the trustees. It cannot assume exclusive ownership and then deny the rights of the beneficiaries under their trust and arrogate to itself a power greater than that of a mere trustee, and prevent the use of the streets and alleys by individual members of the public. The right of the public to use the streets is the right to use them for purposes of travel in the recognized methods in which the public highways of the state are used. Any method of travel, meaning any mode. So what do I mean by that? Walking, riding a bicycle, automobile, horses, scooter, skateboard, motorcycle. That's traveling. Any mode of travel may be adopted by the individual members of the public, which is an ordinary method of locomotion, or even an extraordinary method, if it is not of itself calculated to prevent a reasonable, safe use of the streets by others. If a right exists in a city council to impose a license fee by way of tax on every person, pay attention to this, y'all, on every person using wheeled vehicles thereon, it may in like manner impose such license fee for such use of the streets in every other manner of locomotion or travel, and reach the man on horseback or the pedestrian walking along the same. So what they saying is, if they could issue you a license, let me rephrase that. If they could mandate that you have a license in order to use the streets in an automobile, then they can mandate that you have a license just to walk down the street. That's what they're saying. The right conferred on the city council by the legislature to regulate the use of the streets and alleys of the city do not contemplate a power in a trustee of a beneficiary to deprive the beneficiary of that right. The power provided by ordinance for planting trees in streets to prevent encroachments upon or remove obstructions from the same, to provide for lighting and cleansing them, to prevent and regulate the rolling of hoops, playing of ball, flying kites thereon, or to prohibit any other amusement having any tendency to annoy persons, is conferred for the purpose of keeping the streets in a condition for public use and travel. Any usual method of travel along the streets and alleys of a city cannot be declared a nuisance. The city council may regulate the use of the streets and alleys to the extent that it may require sidewalks exclusively reserved for the use by pedestrians, and exclude certain character of loads, and regulate the width of tires on vehicles used on certain character of pavements, and provide that the rate of speed shall be much less on certain streets than on others, and otherwise regulate the use of the streets, having in view solely the welfare and safety of the public. The city may also regulate certain occupations such as hackmen, draymen, expressmen, and the like. So let's see what a hackman is. We're going to see what these are, because I don't know what these are. Let's see what they are. Let's see what a hackman is. Some of y'all might know. I don't know what it is. I think I spelled that wrong. Let me just see what a hackman is. I don't know what it is. A driver or a hack or carriage for hire. Look at this, y'all. Oh, man. Let me see if I can find something else. A hackman, the driver of a hack, the driver of a hack or taxi. What is a hack? Okay, a driver. That's somebody who's using the road at the place of business. All right, let's see what, I don't know what a hack is. Let me see what a hack is. A verb. Hack. Computers now. Where is it at? Is it in here? Let me see if somebody can tell me. I'm going to go to the chat and see if somebody can tell me what a hack is. All right. Do any of y'all know what a hackman is? Anybody here watching this video, do any of y'all know what a hackman is? Anybody know what a hackman is? Because I don't know what it is. If you do, let me know in the chat, and then we'll get back to it. All right, where we at? Okay, we got hackman, drayman, expressman. Okay, let's see what a drayman is. Hackman seems to be somebody employed for hire or something like that. So let's see what a drayman is. A drayman was historically the driver of a dray, a low flat bed wagon with all sides pulled generally by horses and mules that were used to transport all kinds of goods. Okay, okay. Notice that they're talking about business, y'all. An expressman. Let me see what an expressman is. So these are old terms. All right. A person who collects and delivers goods. Okay, so it seems to be some sort of traffic or commerce. All right. The city may also regulate certain occupations such as hackmen, draymen, expressmen, and the like, for such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions and extortions, and for the same reasons. A license may be exacted for vehicles used in the transportation of goods and merchandise, or of passengers, or for other purposes of traffic. But such license, pay attention to this, y'all. They're saying that they're saying that they can issue you a license for it, but they're saying, but such license is an occupation license. and not one for the use of the streets. I hope that did not go over y'all head, because it damn sure ain't go over my head. I hope that did not go over y'all head, because it damn sure did not go over my head. I'm going to read this again. The city may also regulate certain occupations, such as hackmen, draymen, expressmen, and the like. For such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions and extortions. And for the same reason, a license may be exacted for vehicles used in the transportation of goods and merchandise, or for passengers, or for the purposes of traffic. Traffic, which is a commercial term, by the way, but such license is an occupation license and not one for the use of the streets. Is this making sense to y'all? Because it makes perfect sense to me. Does that make sense to y'all? That makes perfect sense to me. Let's get back to it. The license in the latter named case is designed to operate upon those who hold themselves out as common carriers, and a license may be exacted from such as a proper exercise of police power. But no reason exists. Why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. Is this making sense for y'all? The license in the latter. What do they mean by the license in the latter? They're talking about the transportation of merchandise, goods, passengers for hire, or for other purposes of traffic. That's what license they're talking about. I got to go back and read that again, man. Because I really think that this might be going over some of y'all heads. So I got to do this again. This is going to be my last time doing it. Give me a second. I'll be right back. The city may regulate certain occupations, such as hackmen, using the roads as business, draymen, using the public roads as business, for business purposes, expressmen, using the public roads for business, and the like. For such regulation is of a police character, having reference to the general welfare, as a means of preventing improper exactions and extortions. And for the same reason, a license may be exacted for vehicles used in the transportation of goods and merchandise, or of passengers, or for other purposes of traffic. But such license is an occupation license and not one for the use of the streets. Does this make sense to y'all? Because it makes perfect sense to me. The license in the latter named case is designed to operate upon those who hold themselves out as common carriers, and a license may be exacted from such as a proper exercise of police power. But no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. And these are the cases that he is citing in support of his authorities. Now, these cases right here, they're either going to expressly or implicitly hold what he just said right up here. That's what they're going to do. Anything which cannot be enjoyed without legal authority would be a mere privilege, which is generally evidenced by a license. The use of the public streets, the use of the public streets of a city, the use of the public streets of the city is not a privilege but a right. What is this? Tideman on Limitations of Police Power, Section 281 says, in distinguishing between a license and a tax, it is therefore conclusive that the general requirements of a license for the pursuit of any business that is dangerous to the public can only be justified as an exercise of the power of taxation or the requirement of a compensation for the enjoyment of a privilege or franchise. In Cooley on taxation, y'all remember when I mentioned to y'all about Cooley, and I said a lot of cases back then from the 1800s were citing Cooley. Cooley must be one bad dude, man. In Cooley on taxation, page 596, it is said, a license is a privilege granted by the state, usually on the payment of a valuable consideration, though it is not essential. To constitute a privilege, the grant must confer authority to do something which without the grant would be illegal. For if what is to be done under the license is open to everyone without it, the grant would be merely idle and nugatory, conferring no privilege whatever. A license, therefore implying a privilege, cannot possibly exist with reference to something which is a right, free and open to all, as is the right of the citizen to ride and drive over the streets of the city without charge and without toll, provided he does so in a reasonable manner. That such a right exists in Chicago is recognized in Smith versus McDowell, where it was said relative to the streets of a city. The grant of power in this particular is to be construed in view of purposes for which the municipality is invested with the control of its streets, alleys, and public grounds. The municipality, in respect of its streets, is a trustee for the general public and holds them for the use to which they are dedicated. The fundamental idea of a street is not only that it is public, but that it is public in all its parts for free. For free. That means without taxing, without a license. For free and unobstructed passage thereon by persons desiring to use it. Section 6 of the ordinance provide all monies received from or collected from the operation and enforcement of this ordinance shall make a separate and distinct fund apart from all other monies held or collected by the city government of the city of Chicago and shall be known as the wheel tax fund. The sole use and purpose for which said wheel tax fund may be dispersed or expended shall be for the repair and keeping in good condition of the streets, of such streets, as are under the direction of the city government proper, and shall be expended only as to the commissioner of public works shall authorize, in the improvement of such public streets as he may have directed to be placed in proper condition. It is a fundamental maxim in taxation that the same property shall not be subject to a double tax payable by the same party, either directly or indirectly. It is only when statutes are passed which impose statutes on false or unjust principles or operate to produce gross inequality so that they cannot be deemed in any sense proportioned in their effect on those who are to bear the public charge, that courts can interfere and arrest the course of litigation by declaring such enactments void. It appears from the allegations of the bill and the stipulations of facts that the complainants are taxpayers and were assessed for and paid an ad valorem tax equal to that assessed upon other personal property in the city. This ordinance on its face indicates that its purpose in part is to raise a special fund for the improvements of the streets and provides for the manner of its distribution, and this amounts to a double tax. The exaction imposed is a tax on specific articles of personal property which are required by law to be, and, which the bill alleges have been assessed for general taxation at their value, and upon which taxes have been paid. To tax them again by declaring by ordinance they shall not be used until another tax is paid, levied, as in this ordinance, without regard to the values, is not only double taxation, but it is a violation of the principles of equality and uniformity, which is indispensable to all legal taxation. It imposes a heavier burden on one class of taxpayers than is imposed upon others, and is violative of the principle and uniformity which must underlie all valid taxation. A statute which makes any kind of property the subject of taxation and discriminating imposes upon a double burden for a single object makes the appropriate equality and uniformity impossible, because it is arbitrary and radical departure from both. The authority to impose a tax or to exact a license must clearly appear and must strictly be construed. If there is a doubt as to the right, it must be resolved adversely to it. In this case, there is no express power given to the city. Oh, they're talking about the tax right now. Yeah, that's what they're talking about. All right. But anyway, this is the case. This is the case right here. They're saying that they can't require you to have a license to use the streets. That's exactly what they're saying. That's exactly what they're saying. Let me see what we got here. If you damage property of another, it's a civil matter between two. Let me go and read the chat for a little bit. This is the case right here, y'all. Y'all can go and read that case. That's the case right there. Let me see. Somebody down here. One Moting, the 10th Amendment gives authority to each state to create and enforce traffic laws. Every state requires a license, registration, and some type of insurance for vehicles operated on the public roads. You want to give notice of claim over your automobile and inform all agents you are bringing the property into the Republic. Let me see what we got here. I'm not sure what One Moting is talking about. Unless I would agree with what you're saying, One More Thing, but you don't understand what these terms mean. And if you don't understand what these terms mean, you shouldn't be using them, because I would have never said nothing like that in regards to this. I wouldn't have. Do you need insurance for your automobile? I don't think you need any of that. However, Patrice, you need to be mindful that if you cause someone some damage, to their automobile or whatever, you are liable for that, and it's gonna come out of your pocket. So you can either get you some type of bond as a form of insurance to indemnify you against something like that, or you can get you some insurance or something like that. That's what you can do. That's the case right there, y'all. The states can't require you to insure your car. No, they can't. I'm of the opinion that they can't, to the extent that it infringes on your right to travel. I'm of that opinion. When they say travel, they mean not just in a car, they mean in anything. I'm not sure what the delay is in this video. David, I've read case after case, and if you are in commercial transportation, you need a license. If you don't need anything from them, they don't care. They do what they want, really. Yeah, you're right, David. They actually do. But if you don't know your rights, of course they're gonna do that. You gotta cost them some so-called money. Once you start costing them, they will leave you alone. I'm telling you what I know. They will leave you alone once you start costing them. All right, I'm reading the chat right now. Yeah, I'm trying to see what's going on. Let's go. Do I need to read anything in here again, y'all? Because this makes so much sense to me. This makes so much sense to me. They saying right here, man, the license in the latter named case is designated to operate upon those who hold themselves out as common carriers, and a license may be exacted from such as a proper exercise of police power. But no reason exists why it should be applied to the owners of private vehicles used for their individual and exclusively, used for their individual use exclusively. Meaning, if you just using this automobile for you and only you and your business, they can't require you to have a license to use the streets. It says so right here implicitly. But no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. There's no reason for them to mandate that you need a license to use the public highways. Does that make sense to y'all? Because that's exactly what they're saying. That means they can't do it, y'all. It's not a privilege, it's a right. That's exactly what they mean. Now y'all need to be when y'all doing research, y'all need to be very careful. You need to be very careful, and you need to go and read cases. Make sure you go and read the cases. Because I've seen, let me show y'all something. Is this it? No, it's this one. I was doing some research on this document right here and all the right to travel cases and yada yada yada. And I went to reading some of the cases, and I could not find the citations in the case. But just because you cannot find the citations in the case expressly does not mean it doesn't say it implicitly in the case. So this is why I always advise y'all to go and read the cases. Read the cases, read the cases, read it for yourself. Don't believe nothing what nobody tell you. That includes me. Go read it for yourself. Read it for yourself. Let's get where we at? Let me go back to the chat. All right, what's the let me see. I'm not gonna stay on here long, y'all. Do anybody have any questions? Give me a second, y'all. I'll be right back. All right, sorry about that, y'all. Do anybody need me to break anything down for them, explain something to them? What? Anybody? Matter of fact, let me go. Let me go to this Kentucky case because I think the Kentucky case is very similar to the case that I just read, and I think it's shorter too. Um, it is 80K 656. Let me find that case right quick, right here. All right, this one is 6 questions. I mean six pages. This is a they're sitting in equity, and this is a Kentucky Supreme Court case. It's basically this case is very similar to the other case that I just read. All right. So let's go here. Appellants, being numerous taxpayers of the city of Paducah, allege in their petition that they each own a vehicle employed exclusively for their own private and family use and accommodation, and not for hire or any use by the public or for any other, or by others, upon which they have been assessed by the city an ad valorem tax equal to that assessed or assessable on any personal property in said city, in which they have regularly paid. They further allege that by an ordinance of the city council, they have been required to pay an additional tax of $3.50 on each of their said private vehicles, $3 of which is for the use of the city, and 50 cents for the benefit of, or as compensation to, the clerk of the city council, and that they are required by said ordinance to take out a license for 1 year for each of the said vehicles. An injunction was granted enjoining the city of Paducah from collecting $3 tax and 50 cents fees of the clerk mentioned in the petition. But subsequently, a demurrer to the petition was filed, and the court rendered judgment sustaining it, dismissing the petition and dissolving the injunction. The act of the General Assembly, under which the ordinance was passed, taxing vehicles used exclusively for private and family purposes, and requiring the owners of such to obtain a license, is as follows: that the Common Council of the City of Paducah, however you pronounce it, shall have the power and authority to license and tax all vehicles running in said city or used in the conducting or in connection with the regular business of person or persons so running such vehicles, at the rate of not less than three, nor more than $10. Provided, however, that vehicle owners and vehicles owned and used in the city for family use shall not be taxed more than $3 per annum. The greatest amount of the tax the city council is empowered by the statute to impose upon vehicles of the kind described in the appellate's petition is $3 per annum, and the tax of 50 cents upon each of them for the use of compensation of the city of the clerk of the city council is therefore not authorized but void, whether the statute itself be valid or not. Under other statutes existing at the time the one quoted was enacted, provision was made for an ad valorem tax upon owned vehicles and used in the city for family use only, and as alleged in the petition of appellants, the same property upon which the specific tax complained of was attempted to be levied was also regularly assessed and was assessable for taxation according to value. The necessary result, therefore, of upholding the specific tax upon such vehicles would be subject to the same property to a double tax each year for the support of the city government. So I want y'all, it's the same thing as the other case. So they're gonna cite the same thing in regards to it is a fundamental maximum in taxation at the same property, blah blah blah. I'm not gonna read that. I'm gonna get down to the other part. Right here. We approve of this rule of construction and refer it to for the purpose of showing how duplicate taxation is regarded by the courts and therefore reluctance to sanction laws expressly providing for it. But we do not feel at liberty to adopt, in this case, the legal conclusion that double taxation was not intended by the legislature because if it is not required in express words of the law, it is by necessary implication, and it therefore becomes our duty to pass upon the validity of the statute. We readily concede the supreme authority under which the Constitution of the Legislative Department of Government of Taxation and are aware of the difficulty in many cases of determining the limit fixed by the Constitution to the exercise of that authority. Let me get, they're talking about taxation right now, and I don't really want to talk about that. I think it's going to get to it right here. The power of the legislature to impose license tax and tax on businesses, on business, occupation, franchises, privileges, and etc. being clear, the statute under construction, to the extent that it provides for the imposition of a tax upon vehicles in the city of Paducah used in the conducting of or in connection with the regular business of persons, of the person or persons so using them, is valid, notwithstanding such vehicles may, by a different statute, be subject to taxation according to the value for the same purpose. Where is it at? Where is it at? I'm trying to find a statute. Arbitrary departure. I think this is it right here because they're also gonna hold it too. But if the statute was not otherwise objectionable, the amount of the y'all should go and read this case. By the way, I know I'm all over the place, but I'm trying to pick out the parts that are important because I want y'all to go and see this stuff. But if the statute was not otherwise objectionable, the amount of the tax authorized to be collected is grossly disproportioned by taxes usually imposed in the city, or that, with due regard to the Constitution or the rights of the citizen, can be imposed. For, in addition to the ad valorem tax, to which the property of appellants is subject, each of their vehicles is made liable under the statute for $3 per annum, which in many cases is equivalent to 5 or 6% annum of their value. Such an imposition amounts to the taking of private property for public use without compensation and should not be upheld or enforced. We are therefore constrained to hold it as invalid, blah, 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 so far as it affects vehicles owned and is used for the city. So far as it affects vehicles owned and used in the city for family use only. This is where he's getting that authority from. That's where he's getting it from. I'm not sure what the delay is. All right, y'all. Starting to get a little tired now. I'm not sure what the delay is on it. I don't know. It looks like it's a couple of minutes delayed. But anyway, that's the case right here. This is the case. Let me give y'all this case again. If y'all think I'm lying, go read the case. Because that's exactly what it say. Go read the case. Let me give y'all the case citation again. That's the case citation right there, ladies and gentlemen. Think I'm lying? Go read the case. No. The 10th Amendment does not allow the states to violate. People don't know what their rights are. That's the problem. That is the problem. People don't know what their rights are. They don't want to read. They don't want to read. You're not going to know what your rights are for yourself unless you go and read. You got to go and read. Let me pull up the other case. I think I have some more in here too. Is this? I don't know if this is it. Let me see if this is it. I don't think. Gosh, I don't think. I'm trying to find this other case. This is the Kentucky case. Yeah, let me delete that one. I have a few more on here too, y'all. This is one too. This is a long case too, but this is one too. They ruled in favor of a company. This was a good case. I'm gonna give y'all the case citation for this one. So this is a good case too. Right here. It's a Florida Supreme Court case from 1937. And it's a right to travel case. They ruled in favor of the company. 131, that's the volume, Florida, page 305. In that case, they tried to require this company to have a license because they were transporting, so-called transporting, their own property on the public highways. And they tried to make them have a license. And they told them you can't do that. Go read the case. I already read it. Go read it. Let me see if I can find some. I'm trying to find the short cases. And I already read that one. Is this one? Let me see if this one is one. I think this is one. I think this is one too. This is a case out of Illinois where they tried to require this man who was pulling horses or something like that. They tried to make him get a license. That's what they tried to do. This is how they this is how they get y'all, man. Let me show you how they get you. If you go and read your if you go and read the motor vehicle code or whatever you want to call it for your particular state, you're not going to see this in here, right here. Something like that. You're not going to see hire, for hire. You're not going to see that they took it out. Let me show you what I'm talking about. This is how they trick you. Let me show y'all exactly what I'm talking about. Let's go to the Alabama Motor Vehicle Code. Go to the Alabama Motor Vehicle Code. It's going to be Title 32. And we're going to get into the definitions. See if they got the definitions in here. I think these are the definitions right here. The following mean respect to describe to them and skip. Yeah, okay. This is it right here. See this term right here, driver? Every individual who drives or is in actual physical control of a vehicle. See how misleading that definition is? They don't have it now for and used for commercial purposes or used for hire or something like that. They did this on purpose because the average man or woman who does not study law, if they come in and they read this definition, they're going to say every individual who drives or is in actual physical control of a vehicle. Well, they're going to say, you know, they'll say something, well, I mean, that sounds like me. That's one definition of a driver. Because this term right here, I don't care what it is. This is the term right. Where is it at? Did I delete it? I probably deleted it. Let me go back and pull it up. This is what they're talking about right here. I don't care because this is the driver. This is the legal term for driver right here. That is what they're talking about. I don't care if they took it out and modified it or whatever. I don't care about that because these words have their common meaning and definition. You know what I'm saying? I don't care if they took it out. This is how they get you right here. If you go and read your motor vehicle code or whatever you want to call it for whatever particular state that you're talking about, it's going to look something like that. They took out for hire or used for commercial purposes or something. They took it out. But it doesn't matter that they took it out because they still can't do it because you can't tax a right. You only taxed on benefits and privileges. That's it. They can't tax rights. Go look at your motor vehicle code and it's going to say that. I bet you that's what it's going to say. It's exactly what it's going to say. I'm going to do one more case. This one's only 4 pages. I'm going to do one more and then I'm going to get on up out of here. Give me a second, y'all. I'll be right back. All right, this one is 4 pages, y'all. This is out of Illinois. Is this Illinois or Missouri? Let me see. Let me see which. I got to see which one it is. City of East St. Louis. All right. 1875. This is the case citation, volume 77, page 156. 4 pages long. Let's see what they say, y'all. But I want y'all to pay. Y'all got to pay attention because these people are they slick. They real slick. So you got to pay attention. This was a prosecution for the alleged violation of an ordinance of the city of East St. Louis. The ordinance is as follows. No person, firm, company, or corporation shall, without complying with the provisions of this ordinance, use or cause to be used any wagon, dray, cart, or other vehicle of burden to convey loads within this city or on the streets of this city or hire out, or keep for hire, or use, or cause to be used for hire in the transportation of persons or property from one part of the city to another, or from places within to places without the city, or from places without to places within the city. Any hackney, carriage, omnibus, baggage wagon, buggy, dray, cart, wagon, or other vehicle. Then, following provisions requiring the owner or owners of the vehicles mentioned above to take out a license fixing the rates. The authority claimed for the passage of the ordinance is under the provision of the City Charter of 1869, giving power to license, tax, and regulate and control wagons and other vehicles conveying loads in the city, to prescribe the width and tire of the same, the weights of the loads to be carried, and the rates of carriage. Don't they do this to 18-wheelers? I know they do because I have a CDL license. And this is what they do for 18-wheelers because they're engaged in interstate and interstate commerce. The admitted facts were that defendant kept a family grocery store in the city and had used a one-horse spring wagon without having a license therefore in delivering goods sold by retail to his customers and in bringing loads of goods from St. Louis, Missouri, where he purchased stock for retail at his store, that he never used the wagon for hire or otherwise than in the prosecution of his business as a grocery store merchant. The question made is whether the defendant was required under the ordinance and provision of the charter to take out a license. The charter authority is to license vehicles conveying loads and prescribe the rates of carriages. To license and to prescribe the rates of carriages alike apply to the vehicles named, so it is only such vehicles which are in contemplation of the subjects of the license, in respect to which the rates of carriage are to be prescribed. It cannot be supposed that it was intended to fix rates of carrying in respect of such vehicles as should only be used by persons in the prosecution of their ordinary private business. Let me read that again for y'all. It cannot be supposed that it was intended to fix rates of carrying in respect of such vehicles as should only be used by persons in the prosecution of their ordinary private business. Any provision of that sort is unknown in our legislation, and the enactment or the authorizing of such a provision cannot be imputed to the legislature unless the intention to that effect is expressed in clear and unmistakable terms. It is otherwise as to another class of vehicles, those used in the exercise of the employment of carrying for hire. In respect to such vehicles as those used for hire by hackmen or draymen and the like, it is customary within municipal authorities to regulate and fix the rates of carriages. It is an ordinary police regulation to protect the public against extortion and imposition on part of those engaged in the business of common carriers for hire. One using a vehicle not for hire, but only in the course of his ordinary private business, does not come within the reason or necessity of any such municipal regulation. Did y'all see that? I guess y'all ain't. I gotta read that again, huh? Do I have to read that again? They lying to you, man. They're lying to you. These people real slick. You gotta watch. You gotta do your research on these. They real slick. Let me read this for y'all again. One using a vehicle not for hire, but only in the course of his ordinary private business, does not come within the reason or necessity of any such municipal regulation. The provision of the charter as to prescribing the rates of carriage can reasonably apply only to such vehicles as are used for hire. What? Under the rule of strict construction, which must be applied in such a case, when they talk about rule of strict construction, we're talking about a fundamental right here. What fundamental right are we talking about? The right to travel. That's what we're talking about. And so anytime that they are trying to regulate a private right, they have to apply, the so-called courts have to apply the principle of strict scrutiny. Under the rule of strict construction, which must be applied in such a case, we are of the opinion that the authority here to license is qualified by the clause for prescribing the rates of carriage, and that the true construction of the charter provision is that it does not authorize the licensing of all vehicles conveying loads in the city. What? Even though it says it, really? Even though it says it, it's still not really. That's why I keep telling y'all to go and read these cases. The judiciary of the past did not fail us. They did their job. They did their job. They did their job. They did their job, y'all. They did not fail us. They did their job. I gotta read it again, man. I gotta read it again. I gotta read this again, man. I'm gonna start right back up here. One using a vehicle not for hire. And I want y'all to pay attention to something. This man he had a horse and carriage. But I want y'all to see how they're calling his horse and carriage a vehicle. All right, pay attention to that, because that's how these people think. One using a vehicle not for hire, but only in the course of his ordinary private business, does not come within the reason or necessity of any such municipal regulation. The provisions of the charter as to prescribing the rates of carriage cannot reasonably apply only to such, let me rephrase that. The provision, because I read that wrong. The provision of the charter as to prescribing the rates of carriage can reasonably apply only to such vehicles as are used for hire. Now, I guarantee y'all, go and read your motor vehicle code and look for the definition driver, and you're not going to see anything in there talking about for hire or interstate commerce. They took it out. And they did that on purpose because they trying to trick you and mislead you. That's why they did it. Under the rule of strict construction, which must be applied in such a case, we are of the opinion that the authority here to license is qualified by the clause for prescribing the rates of carriage, and that the true construction, this is what they're supposed to do, y'all. Anytime you go into court and you saying that these people are infringing on your private fundamental right to travel, they are supposed to apply this doctrine of strict scrutiny, meaning they have to strictly construe this statute and limit it to its scope. And they got to tell you what it means, like they doing in this case right here. That's what they're doing. Under the rule of strict construction, which must be applied in such a case, we are of the opinion that the authority here to license is qualified by the clause for prescribing the rates of carriage, and that the true construction of the charter provision is that it does not authorize the licensing of all vehicles conveying loads in the city, but such only of them in respect to which is proper and customary within the municipal authorities to prescribe the rates of the carriage, viz., those used for hire by common carriers in the city for hire. What? A somewhat analogous provision in the charter and ordinance of the city of Chicago came under consideration in the case of Farwell et al. Versus City of Chicago, where it was held not only to apply to the case of wagons used by the defendant in the regular course of their business as wholesale merchants, but that it only extended to the wagons of common carriers for hire. This is why you need to go and read. Y'all, they're not going to tell y'all this, man. So let's see what the disposition was of the case. So it says, holding that the appellant did not, by the acts complained of and admitted, incur the penalty claimed for not taking out a license for his wagon, the judgment of the court below must be reversed. So they ruled in his favor, and they said it didn't apply to him. They're not going to tell y'all this today, y'all. This is about money, man. They're not going to tell y'all this stuff, y'all. They're not going to tell y'all this. They're not going to, and I want y'all to pay attention because this was in an equity court. All of these cases was in an equity court. Let me see. Hold on. Are they sitting in equity? Opinion of the court. Well, let me see. No, I think this was an appeal. I don't think this was an equity court. The other two cases were in equity. The Kentucky case and the Illinois case, they were sitting in equity. Let me give y'all this case too, by the way. Let me find this case citation. I'm gonna give it to you so you can go and read it. 7711-156. They don't even have that case on here. Right here. That's the case right there. Joyce versus East St. Louis. That's the case that I just read. That's it right there, y'all. These are the cases right here, y'all. If these cases that I just read tonight do not convince you that the judiciary of today is lying to you and committing treason, and the judiciary of the past were actually doing their jobs, I don't know what to tell you. Because these cases clearly hold that they cannot require you to have a license unless you engage in some form of business. So essentially what they're saying is, let's say you own a business in the city and you sell food or whatever in the city. You are not required to have a license to load up all of your food in your private automobile and travel in it to the city. They can't require you to have a license for that. They can't require you to have a license for that. Go read the cases, y'all. Go read the cases. Y'all hit that like button for me. If y'all don't mind, hit that like button for me. If you haven't already, hit that like button. This is what they do, y'all. They lying to you, man. They're lying to you. They're lying to you. They're lying to you. They are lying to you. Let me show y'all what I'm talking about when I mean they lying to you. Let me show y'all this BS. Look at it. Look at these attorneys, y'all. No, they don't know what they're talking about. This is the question. If I'm traveling in my vehicle for personal use, do I need to have a license plate, insurance, vehicle registration, blah blah blah? Look at these attorneys. Look at them. The arguments you mentioned that the individuals have a right to travel without a license or other documentations as long as they are not engaged in commercial activities has been presented in court cases before us, but has generally not been upheld. Courts have consistently affirmed that the ability of states to impose reasonable regulations on the use of motor vehicle, yeah, because a motor vehicle is used for commercial purposes. They're presuming that it's a motor vehicle. And then when you object and you say it's not a motor vehicle because it's not used for commercial purposes, they're going to ignore you and call you because they don't want people to know that this is how this stuff works. They don't want y'all to know that they're committing treason. That's what they're doing, though. That's what they're doing. Now, the statutes, these statutes are not unlawful. They enact them, in my opinion, in the correct manner, but they are unlawfully applying them to people who they do not apply to. That is what they are doing, and that's what they don't want to tell nobody. They hiding this stuff from y'all. They hiding it. They're hiding it from you, man. They're hiding it from you. Go and let me. I'm gonna do something just random right now. Give me a second, y'all. I'm gonna be right back. I'm gonna do something just random. I'm gonna start looking up the legal definition for driver in so-called states all over the country. And I'm gonna show you that they hid this stuff, man. They hid it. I already saved that one. Let's go here. So we're gonna go to let's say Georgia. We're gonna go to Georgia Motor Vehicle Code. Georgia Motor Vehicle Code. And we're gonna see what the legal term for driver is in Georgia. Let's see what it is. Identification and regulation, driver's license, uniform. Let's see if we can find it. Identification, regular registration of motor vehicles, certificate of title, identification and purposes of driver's license. I can't find. Let me see. General provisions. It might be in here. Definitions. Let's see if it's in here. Yeah, it's gonna be in here. Let's see what the legal definition for driver is. Look at this. The same definition that they got in Alabama means every person who drives or is in actual physical control of a vehicle. See this, y'all? But I don't care that this is what it says because the word driver or drive, these are variations of the term driver, and it still means the same as it meant in 1891. But they're hiding this from you. That's what they're doing. So that's Georgia. Let's go somewhere else. That's Georgia. Let's go somewhere up north. We're gonna say New York. Let's go to New York. New York, Colorado. Let's see if this is it. Words and phrases defined. It might be in here. Let's see if it's in here. Okay, so it's gonna be down here somewhere. Let's see what it says for driver. Let's see. Every person who operates or drives or is an actual physical. This is the same thing that they have in Alabama, y'all. Whenever the terms chauffeur or chauffeur license or operator license are used in this chapter, such terms shall be deemed to mean driver and driver's license respectively. Deemed, that's a legal fiction. It's subject to being rebutted. But anyway, every person who operates or drives or is in actual physical control of a vehicle. Vehicle is a commercial term because I just told y'all, didn't I just tell y'all that in this case in Florida, not Florida, but what was that? I don't know what it was, but they were calling a man who was pulling a horse and a carriage. They were trying to label his horse and carriage a vehicle. Now I just tell y'all that because that's what they were doing in that case. Every person who operates or drives or is in actual physical control, this is what they're doing. They're lying to you, man. Man, these people, I don't know what else to say, y'all. Let me go somewhere. I'm going to look at a few more. This is my first time doing this. Um, let's see. Let's go to Chicago. Let's go to Illinois. Let's see what they are saying. Vehicle code. Is this it? Let's see what the legal definition. Okay, titles and definitions. Okay. Rules of the road. This damn thing so long. Where we at? Campfire, business district. Okay, so it's in alphabetical order. Commercial driver's license. Let's go to driver. See what driver means. Coming up on it. Almost there. Driver, right here. Look at this, y'all. This is the definition of driver in Illinois. Driver, every person who drives or is in actual physical custody of a vehicle. This is the same definition. Are y'all seeing this, man? Are y'all seeing this? This is the same definition, y'all. The same definition. Same definition. Man, let's go somewhere else. That's the fourth one I done did so far, and all of them have the same definition. All right. We went to New York, Illinois. Let's go to Texas. Let's try Texas out. Texas Motor Vehicle Code. Let's see if we got it right here. No, this ain't it. General provisions, purpose, construction, definitions. Okay. Let me see. Let me go. Let me see if I can find the definitions. Construction reference, section 104 in this code that the Department of Public Safety means, blah, blah, blah. All right, this is gonna take too long. You know what? Let me try it this way. Driver. Oh, good God. That's how many times the word driver is used in here? Yeah, we ain't finna do we ain't let me go somewhere else. That's too many times the word driver is used in there. That'll be in there all day. So let's go right here. General provisions, right here. Purpose of code, construction, definitions. Okay. This is how you do your research, y'all. This is how you do your research. You gotta go through all this stuff. Traffic and vehicles, roadways. Let's try here. Let's see if the definitions are in here. Rules of the road, Department of Motor Vehicles, miscellaneous enforcement, rules of the driver license. It might be in here. Let's see if it's in here. It's taking too long. All right, let me go. I'm gonna look it up on Google. Let me see if it's in here. It might be in here. A Title 7 Transportation Code. Sometimes in registration. All right, let me look it up on Google. Vehicle code, driver definition. Transportation code definition. Let's see if this is it. Persons and governmental authorities definitions 541. Let's see if this is it. It's probably it right here. Passenger motor vehicle. Okay, it's gonna be up here somewhere then. Director, local, flag. Let me see. All right, I don't see it in here. Let me go somewhere else. This is getting a little too hard. All right, Texas. Let's go to Mississippi. Mississippi Motor Vehicle Code driver definition. Driver means, all right. Driver means any person who drives, operates, or is in physical control of a commercial motor vehicle on the public highways, or who is required to hold a commercial driver's license. All right, so this, let me make sure. I gotta make sure. I think this may be the commercial motor vehicle code. Driver's license. Let's see, chapter 1, driver's license. I ain't got time. Well, I can't even find it. I ain't finna go through all this. This might be it. The following words and phrases, when used in this article, shall, for the purpose of such law, have the following. Okay, it might be. No, it ain't in here. Next part of the code. All right, well, I don't know where it's at. This one's a little too complex, but I just pulled up like 4 of them, and all of them pretty much had the same legal definition for driver. All of them. That's crazy. Crazy, crazy. Somebody said they sent me an email. Robert, how you doing, Robert? How you doing, man? These cases right here, I'm gonna point to these cases again. Go read these. Go read this case right here and this case right here. There are more, but they're going to tell you that there's a one. Let me hold on. I gotta go and find ex parte versus um Dickey. Dickey, what is it at? I gotta put that case in there too, y'all. I'm sorry. Ex parte Dickey, 76 West Virginia, 576. 76 West Virginia, 576. That might be a good case. Ex parte Dickey, right here. All right. Go read this case too, by the way, y'all. I'm about to check your email right now. Give me a second. I'm checking my email right now, y'all. That's what I'm doing. Checking the email. Look at these. I ran into these cases back in Palm Anderson case. Look at these. I don't see no cases on here. Oh, okay, okay. Okay, I see what you're talking about now. I'm looking at something right now, y'all. Yeah, Shuttlesworth versus Birmingham, that is valid. No state may convert a secured liberty into a license and attach a fee to it. And if they do, you can engage in that right with impunity. That's right. I got that from Carl Miller. A license means leave to do a thing which a licensor could prevent. The object of a license is to confer a right of power which does not. Yeah, they right. All of this stuff is right. Those who have the right to do something cannot be licensed for what they already have a right to do. Such license would be meaningless. Yep. Um. Yeah, this is where I started at with a lot of these cases right here. The court makes it clear that a license relates to the qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside the business enterprise, I have a lot of these cases on my computer. I did read some of these cases too, by the way. Thank you, by the way, too, Robert. But yeah, I did read some of these cases. I sure did. Yeah, I've been watching that Carl Miller video that was posted. Great info. Um. Anyway, y'all, I'm getting tired, y'all. I'm really getting tired. But hopefully, y'all need to go back. Just go back and watch this video or just read this stuff because these people really think that you crazy. They are making this stuff up, man. They don't want y'all to know this stuff. They don't want nobody to know this stuff. They're hiding this stuff. I just showed y'all. I went to like four different states, and I looked into their motor vehicle code for the legal definition for driver, and almost all of them are the same. They say the same exact thing. They're hiding this, man. They hiding it. That's what they doing. This I got a lot of stuff from here. I'm gonna have to go and read some of this stuff. That's what I'm gonna have to go and do because this is some of this stuff is pretty good. But I would advise y'all to go and read these cases for yourself. Do not just go based off what somebody has cited, has cited for you. Like this right here, I'm not gonna make a conclusion based off any of this stuff that I'm reading unless I have already read a case that basically held the same thing. That's just how I operate. All right, y'all. I'm tired. I'm tired. I gave y'all the cases. Y'all go read these cases, y'all. Go read the cases. I'd like to thank everybody who has subscribed to my membership. I don't care what it was, even if it's $1. I really appreciate it because I put in a lot of work on this stuff, y'all. A lot of work. And this stuff is mentally exhausting, in my opinion. So let me go here. I'm gonna do this before I leave, and then I'm gonna get on up out of here. If you would like to support my channel, I would really appreciate it if you did. Hit this join button and just hit one of these, whichever one you can afford. I don't care, whatever. I'm going to respectfully request everybody who watches this live and who's watching it now, if you haven't already, please just go on ahead and join my jury members membership. I would really appreciate it. Also, if you haven't already, go ahead and register for draft class. Let me go down and tell y'all this right quick. Draft class will be in, I think it's on the 20th. So we got 17 days. Where we at? Give y'all some details on it right here. If you want to attend draft class this month, send me a $50 deposit via Cash App, Zelle, or PayPal, plus the transaction fee, and then email me. Once the deposit is made, I will email you a registration link. The deadline for full payment is May 18th, 2024 at 11:59 p.m. Let's go here. Where we at? Trying to find the link. I mean the video, not the video. It's right here. All right, it'll be May 20th, 22nd, and 24th. It's going to be 3 days, 1 week, and 3 days, another week. So altogether, it'll be 6 days. It's going to start at 7 p.m. and it's going to be a 3-hour course. Admission is $200. If you got to make installment payment, I don't care. Okay, just come to class. Come to class. Come to class. Come to class. I only want 10 students. That's all I'm taking. It's going to be an 18-hour class. Come to class, y'all. Oh, I'm tired. I'm tired. All right, y'all. I'm about to go ahead and get off here. I'm starting to get a headache, y'all. Starting to get a headache. Again, if y'all don't mind, please go ahead and just join my jury memberships. I would really appreciate that. Yeah, that's the motion class, Mr. Hodges. Yes, sir. That's the motion class. It's basically I'm just gonna teach you how to draft motion, how to properly put together a motion. All right, that's half of the work. The other half of the work is you're gonna have to do, but I'm gonna show you how to do it, and hopefully that'll be enough for you. Um, you're just gonna have to read cases though. That's what you're gonna have to do. You're gonna have to read cases. Anyway, hopefully this video helped y'all and proved to y'all the point that I was trying to make, that you have a right to travel without a driver's license. And I'm of the opinion that since you don't need a driver's license for it, that you don't need a license plate for it. That's what I'm of the opinion of, because it's private. Why are you putting public property on private property anyway? This, to me, this is some sort of in my opinion, this it constitutes some sort of taking of private property and using it for public purposes without compensation. Let me show y'all what I mean. I'm gonna see if I can find that case right quick, because I downloaded it. This ain't it. Where is it at? Public right to train left. No, that ain't it. I'm trying to find it. Quasi judicial, due process, tax private property. I don't think that's it either. Tax private property, corporate territorial jurisdiction. I'm trying to find it. If I can find this thing, that ain't it. Where's this thing at, man? Historic principle, that ain't it. Fundamental name change. public, let me see, private property. I don't think it's gonna be in here. I can't find it, y'all. I wish I had it. I tried to label it, but I see I couldn't. Where is it at? No, that ain't it. I don't think it's in here. No, it ain't. I have to find it another day. I tried to find. I'm sorry, y'all, but I'm getting tired, and it might be in here. Let me see. What is it? This is download. I think I already did that. No, it ain't. Yeah, let me get off here, man. I'm tired. All right, y'all. That's gonna be it. I'm tired. That's gonna be it. Everybody enjoy your evening, your Friday evening. I hope this video helped y'all. Go read the case. I don't know what else to tell you. Um, the Supreme Litigant is out, man. Y'all be safe and enjoy your weekend. Police officers are not required to know the laws they enforce. See the rulings when case Helen Hines versus North Carolina. Yeah, I know what you're talking about. Hines versus North Carolina, where they're allowed to make a reasonable mistake of law. Yeah, I know exactly what you're talking about. I was in college when that case came out. All right, y'all. Peace. Everybody enjoy your weekend. Be safe. The Supreme Litigant is out. Peace.